Welcome to Crestview Community TV's Court TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today we're watching the miscellaneous court date / VOP court date. You're going to see, by VOP we mean violation of probation, and you're going to see a lot of people this morning who are, a lot of them are going to be incarcerated because they violated their probation. When you violate your probation, you're not entitled to a bond. Doesn't mean you can't get one, it means it's harder to get one. On a new law violation, most people are entitled to a bond, absent some major circumstances. When you violate that probation, though, you're not entitled to a bond, but you can get one. But that leads this court date to having a lot more inmates. Now, when you're called to the podium, a couple things you can do. You can enter a plea to your VOP and say, yes, I did it, I violated my probation. And you can get sentenced. You can ask for a continuance. Let's set this down the road, maybe try to work out some details, maybe try to work out a deal. Or you can ask for a contested VOP hearing, which will be set at a later date in one of the afternoons of this miscellaneous date. Now, VOP hearings are very hard to win. It's a different standard of proof. We don't see a lot of them because it's rather easy for the state to prove if you violated your probation or not. So you're not going to see a lot of contested VOP hearings. Now, in addition to the violations of probation in the mornings, you're going to see some other smaller, shorter hearings, things like bond hearings, or things that don't take a lot of time, normally 15 minutes or less on these morning hearings. Anything longer than that is going to be set to the afternoon.
All right, thank you.
And Mr. Wagner is going to enter an admission to the violation of probation, be adjudicated guilty, $100 VOP fee, and then reinstate probation with the original terms and conditions.
All right, Mr. Wagner, would you raise your right hand to be sworn, please? Do you swear or affirm the evidence you're about to give be the truth, the whole truth, and nothing but the truth?
Yes, sir.
So you heard your attorney indicate that you're going to admit the violation of probation, and based upon a written plea agreement, you'd be adjudicated guilty, pay a $100 violation of probation fee, reinstated to your probation under the original terms and conditions. Was that your understanding?
Yes, sir.
Is that what you want to do today, sir? Has anybody forced or coerced you?
No, sir.
All right, I'm going to find that, and he's admitting the violation.
Yes, sir.
Do you have a score sheet?
Your Honor, I'm sorry, I had some technical issues printing that thing out, so I'll have to get that to the court. I can...
Is this a guidelines sentence?
No, Your Honor, it is not. It was originally a downward departure at the original sentencing. It will be 109.7 points when I file it, which I will get to the court today.
All right, we'll let the record reflect it's a legitimate, uncoerced plea agreement then, and then I'll sign the sentencing guidelines when you get them.
Thank you, Your Honor, and that was our intent.
All right, Mr. Wagner, I'm going to find that you have in fact violated your probation. You'll be adjudicated guilty of the violation as well as the underlying offense. I'm going to order that you pay a $100 violation probation fee. You'll be reinstated to the probation that you were on, subject to the original terms and conditions. So you have a right to appeal the legality sentence to court. If you can't afford an attorney, one will be appointed for you. You have 30 days from today to file your notice of appeal. Good luck to you, sir.
Thank you.
Your Honor, that's all I have.
Your Honor, Charles Berry with State Probation. Mr. Wagner has to have a GPS monitor. It was originally at $1 a day. We request it stay at $1 a day. And he has to remain in custody until we can get out there and hook it up.
All right, well, that was part of the original terms and conditions of the
Correct.
probation.
And we'll get out there today.
All right, they'll be reinstated. He'll be required to have the GPS monitor at $1 a day, and he'll be held until the monitor is in place.
Thank you, Your Honor.
You're welcome.
We'll be out.
Okay.
See, Seth, I've got two different ones. Mr. Flowers, you've got a
Mr. Chansey, sir?
Seth Chansey, okay?
Yes, sir. Mr. Chansey is here. He's seated on the front row, Your Honor. It's a motion hearing that I filed on his behalf, and in response to that, I believe the state had filed a motion also. May I, Your Honor?
Yes, sir.
Mr. Chansey is co-defendants with his wife, Madison Chansey, and when they were arrested, the court had set a bond, $100,000 bond, and one of the terms was that Mr. Chansey could not communicate with his wife, Ms. Chansey, during the pendency of these proceedings. Mr. Noakes represents Ms. Chansey. He was here, Mr. Noakes, on a motion within the last, I think, 2 weeks, asking that the court grant Ms. Chansey's motion to be able to communicate with her husband, Mr. Chansey. The state objected, and the court ruled that she is allowed to communicate with Mr. Chansey, but they shall not discuss the facts of the criminal case. I filed on Mr. Chansey's behalf a motion out of an abundance of caution, because the order of this court is that she can communicate with him, she can call and ask him a question, but he's not allowed to talk back to her. Judge, I have a copy of that order.
Please.
So as the state of the case is this, she can talk to him, he just can't talk back. Secondarily, the state, after I filed my motion for the first time, asked that bond be modified to place him on pretrial services supervision. Now, they did that in the other case, too, and the court ruled that she shouldn't be on pretrial supervision. One wonders why it would be necessary for him. So that's where we are, Judge.
That's correct, Judge. Mr. Chansey and his co-defendant, Ms. Chansey, were both charged with aggravated child abuse of their 5-week-old baby. No contact with co-defendants was the only condition that was applied at first appearances. State would maintain its objection to modification of the no contact between the co-defendants. I believe that needs to remain in place in order to properly prosecute the case and is in the interest of justice. We also did file our own motion for pretrial services, weekly reporting to pretrial, given that this is a first-degree felony case with a live child victim. We'd note that even in misdemeanor battery cases, pretrial supervision is a standard condition. We're also requesting a no contact with the child victim in this particular case. Our concerns for the safety and welfare of the child remain.
Judge, may I be heard?
What'd you say?
May I be heard, sir?
Yes, sir.
Judge, any communication they would have with the child, if at all, would be under the auspices and supervision of the dependency court rule and Department of Children and Families, and they're not doing anything to violate that. But with respect to the pretrial services, he's been out on bond for some time now, and no one thought that that was important until I filed my motion for him to be able to talk back to his wife when she calls him. Judge, we just want him to be able to, when she calls him on the phone, for him to be able to talk back to her. If she can communicate with him, we want him to be able to communicate back. That's all, Your Honor. And I understand the state's objection and why they're doing it, frankly.
Well, it seems like, to me, there ought to be some uniformity between the conditions. I'm going to grant the defendant's motion to allow no violent contact with the co-defendant. Her name is Madison Rose Chansey, I believe.
It is,
that
Your
right?
Honor.
I'm going to allow that he can have no violent contact with the co-defendant, Madison Rose Chansey. And neither one are to discuss the facts of the case. And do you understand that, sir? Yes, sir. If you have some communication with your wife, it's not to discuss the facts of this case. You understand that? And what's the situation with the pretrial services then?
Neither are supervised by pretrial services. The state's requesting that he be placed on it. They were here 3 weeks ago asking that the wife be placed on it, and she was not. We're suggesting that he shouldn't be either. There's no reason for it, is our position, Your Honor.
Why do you feel it's necessary to have him on pretrial service? What kind of a bond is he on now, a cash or professional bond?
100,000 cash or professional, Your Honor. I think it's correct. 100,000 cash or professional.
Okay.
Judge, part of our concern is to ensure that he's complying with the dependency case. As Mr. Flowers said, there is a contact provision already in place with the baby in the DP case. However, my concern is that this court does not have any way of holding third parties accountable should they allow contact between the co-defendants and the baby, and that we have no input or control and may not even be aware if the contact provision with the child and the two defendants changes.
What are the conditions of the dependency case as far as contact goes?
I believe there is a no contact at this time
They don't allow
between...
it. I'm sorry. They're not allowing contact, Your Honor.
Okay. All right, well, let's do this. I don't know there's a need for pretrial services, but as an additional condition of this bond, I'm going to require him to comply with the terms and conditions of the dependency court, as well as the terms and condition of this bond. And if there's a no contact between him and the child, and I can understand that from reading this, the motions, sir, that means you don't have any contact with the child. If you do, then not only are you in violation of the dependency order, you're in violation of this bond, and your bond can be estreated, and you can be placed back in the county jail. Do you understand that? All right. Anything else?
Your Honor.
Nothing
right.
further, Your Honor. Your Honor, may I approach briefly?
Yes, sir. Mr. Flowers, I'm going to ask you
Apologize.
I'm going to ask you to prepare that order as well.
I'll be pleased to
And
do
did
so.
you want a copy of this order back?
Yes, sir. And, Your Honor, there is a defendant, Mr. Tolar, who was on the docket today.
Right.
Attorney Marty Noakes had contacted me, and he's in another court, and asked me to cover that matter for him today.
Okay, that's, I see it here. Case number 22-632.
And, Your Honor, Mr. Noakes' request is to place the matter on for June 26th, I believe is the date. June 26th. And this is Mr. Tolar, and
No objection from the state, Your Honor. Well,
take it right now.
he was set for arraignment today.
All right.
Get back with you in a little while.
So he's entering a plea not guilty then?
He's entering a plea of not guilty at this point in time.
All right, we'll set it for a pretrial conference, June 26th, with a docket date July 3rd. Jury selection will be July 10th.
Thank you, Your Honor.
Yes, sir.
And Your Honor, will the VOP also track with the
We
new
would
case?
ask. Thank you, Judge.
All
That's
right,
what we would
we'll
ask.
let the VOP track with the new law violation. Brian Williams. Are you Mr. Williams? All right, Mr. Williams, the court record indicates you're represented by Mr. Moore, is that right?
No, he was suspended, and
I know he's got, there's some
Gonna have to
issues
go
on.
it
Do you
alone.
have a lawyer now?
no, I do not.
You're not. You understand you're entitled to be represented by an attorney. If you can't afford an attorney, the court will appoint one for you.
Yes, I understand that.
It seems like this is familiar to me. Did I appoint a lawyer for you the last time you were here?
No,
Okay. Can you afford to hire your own lawyer, sir?
not at this time.
Have you filled out a financial affidavit? How much, approximately how much, what's your income, sir? Do you work?
I have a business. I make about $20,000 a year off of it. I have some retirement.
Do you have any, are you married, sir? Do you have any dependents? And you make $20,000 a year?
Yeah.
Well, under that, he's not going to qualify, I don't think, under the guidelines. Sir, did you want an opportunity to see if you can hire another lawyer?
I don't think I need to do that. This is pretty cut and dry and simple stuff.
You want to represent yourself?
Not really, but I don't see that I have a whole lot of choice.
Well, okay, you're telling me you don't want to represent yourself, so again, sir, do you have any assets from which to hire an attorney right now?
Take me some time to get at them.
Let me tell you what I'm going to do. There's a docket, there's a hearing next week, Monday, May the 1st, isn't there?
It's docket day.
Docket day? So I'm going to pass your case to May the 1st and give you an opportunity to see if you can hire a lawyer by that time. If you can't, I understand the situation you're in, and you may have already paid significant funds, so you may not be in a position. Pardon me?
That is the problem.
Yeah.
And, Your Honor, I'm sorry, this is the case, I'm handling Mr. Williams, this is for the state. I do understand he's got 2 requests for the court, but one I can put on the record, the no contact provision with Ms. Ayer, his co-defendant, we have no objection to changing that to a no violent contact. So we can remove that, but we are opposed to the electronic reporting that you're requesting.
Okay?
All right, I'm going to pass it for 1 week to May 1st to see if he can hire a
I'm going to
lawyer.
put it on May 4th instead.
Okay.
That'll be next.
All right, May the 4th? All right, let's give him until May. I'm going to pass your case, sir, till May the 4th to see if you can hire another attorney. If you can't, come back and we'll see about, you've got unusual circumstances, and it may be that the court will appoint you an attorney if you can't hire another one by May the 4th. All right, we'll see you back on May the 4th then. Christopher Kearns. Christopher Kearns, Dixie Dan Powell, is he here? Robert Lundy. His attorney is Brandon Stewart, is he here?
Good morning, Your Honor.
Good morning, Mr. Stewart.
May it please the court, Brad Stewart, on behalf of Mr. Lundy, Judge. This is 20 CF 800, 20 CF 2291, and 21 CF 703, Judge. The basis for the violation of probation is a new law misdemeanor violation. Judge, we are filing a motion to suppress in that matter. It's going to be dispositive. It is going to be set for May 25th. Judge, I do need to continue this matter so that we can address that issue.
Any objection?
No objection, Your Honor.
All right, I'll pass it until, let's see. Criminal motion, there's May 30th, that the misdemeanor case should be resolved by then?
Yes, Your Honor.
All right, I'll pass it to May the 30th, and that would be at 9 a.m.
Very good. Thank you, Your Honor. That's all I have before the court may be excused.
Yes, sir.
Thank you, Your Honor.
Kenneth Harmon. All right, Mr. Harmon, court docket reflects that you're charged with violation of your probation and that at this point you don't have an attorney. Did you want to be represented by an attorney, sir?
Yes, sir.
All right. Can you afford to hire your own attorney?
Possibly. I mean, I don't even know if I need one, really, because I think this case is kind of a little screwy, honestly.
Well, you said you want to be represented by an attorney. I'm going to appoint, have you filled out a financial affidavit?
I haven't. Nobody's kind of led me in a direction, like when I went to first appearance, they said to issue him a public defender, but I don't know, my problem with this whole thing is the stop itself. I never got issued a ticket or anything like that, and
You
I
may
know
want,
that's.
you may want to, if you feel as though you have valid grounds to suppress evidence or it's illegal arrest, then having an attorney can be a benefit to you, sir.
Yes, I agree.
All right.
But I mean, this whole
Approximately-
thing has kind of got me on hold because I got no bond or nothing. It's probably killed my job and everything, you know?
All right. How much do you earn, sir?
I earn probably around $2,400 a month or more.
Do you have any assets from which to hire an attorney?
I have a little bit, yes, sir.
Do you have any dependents?
I take care of my 82-year-old father. I have a couple of Yorkies that I need to be looking in on, and
Well, do you have
I
any?
have my 80-year-old mother been going and checking on my 82-year-old father.
Do you have any legal dependents, sir? Children under the age of
No.
18, a wife, or?
No, well, I'm married, but I haven't heard from her, so.
And when's the last time you had any income?
When I was arrested.
Okay. And you're in jail without a bond right now?
Yes, sir.
All right, I'm going to appoint a lawyer to represent him.
Can I get a bond? Because I really,
Well, that's for another matter. The lawyer's going to have to file a motion to that effect, sir. I'm going to appoint an attorney to represent you, and we'll set this back for, let's see, when are the VOP hearings?
it's
Your
on
Honor,
the,
if I may, Ariana Leone for the state. I do have an offer for Mr. Harmon, if I can just place it on the record so he's aware of it. And the offer would be that it be reinstated to the original terms, but probation be modified to 6 months of community control, followed by drug offender probation with curfew 7 to 7. And that he submits to substance abuse evaluation and treatment.
would
Shriver's,
that
did you,
just take effect now?
The
Because the
judge may
thing was, I
wanna,
was pretty much completed with my probation. I'd already done, I mean, without a doubt, I screwed up, but I had already done, I don't mind doing drug classes and everything again. I had already done that.
if
I'm
I may,
just
if
trying to get my
I
life
may
back here.
suggest something, Your Honor. If we could set this case for May 4th next week, maybe as the time to meet with his attorney, work out the agreement, and then enter,
Jay Williams.
yeah, I've appointed the Public Defender's Office to represent you, sir, and the state attorney can communicate that offer to your attorney, and she can discuss it with you. It may be something you want to consider. Community control is not easy to do.
I've done that before a long time ago,
All
but.
right, I'm going to appoint Public Defender's Office to represent him, and we'll pass it to May 4th next week at 9 a.m.
All right.
thank you.
Okay. Julia Sledge. Are you Julia Sledge? Mr. Sledge, looks like you've been charged with possession of a controlled substance, criminal mischief, and possession of drug paraphernalia. The record indicates you don't have an attorney. Did you want to be represented by an attorney in these matters?
I don't know if he filed I don't know, but I don't talk to Mr. Tony already.
I don't see him here this morning.
I think he's.
Are those not the charges?
It is the charges, Your Honor. He's already been arraigned. He got
he
put on the
has.
docket from pretrial earlier in the week. He's currently represented by the Public Defender's Office, but he said he wanted to hire a private attorney, so I wanted it put on today's docket so we could
Okay.
expedite the process.
And he actually fired us. On the record.
Sir, did you hire Mr. Tony?
As far as I know of, I mean, he said I think he had said he was gonna have somebody fill in. I think he had some, because it was just a spare the moment type thing, and then they said, instead of setting it off for a little minute, I guess they said come back. I came Monday, they said it'd be Thursday, but I guess he had some stuff he had to do. I don't know what's going on.
Let me ask you this. Have you paid him?
Yeah, What did you talking about?
Well, I'm asking you, have you paid him his fee?
Yes, sir.
You did. Raise your right hand to be sworn, please. Do you swear or affirm the evidence you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
And what is your name, sir?
Julius Sledge.
All right, you put your hand down, sir. All right, Ms. Rivers has indicated that you were represented by the Public Defender's Office, you terminated their services in the past, and you wanted to hire your own attorney. And you've told me that you've hired Mr. Tony to represent you. Is that right?
That's what I just told you.
Okay, now I'm asking you, sir, have you paid Mr. Tony's fee?
Mr. Tony's fee is, can I put my hand? Because it's a phone. I texted him this morning because I went to his office, but I don't think nobody was in there. But I know he said he wasn't going to be here or he was going to have somebody fill in. I'm not no attorney. I don't know. I just wanted to get somebody that I know was going to handle my case properly, period.
Okay,
So-
and my question is that going to be Mr. Tony? Have you paid his retainer?
Your Honor, I just went over this with you. I've talked to Mr. Tony. We've been through this, and Mr. Tony is going to be my attorney. I don't know what else I could tell you. I don't fill out paperwork.
Well, what you can tell me, sir, is either you did pay him or you didn't pay him. What is it? That's a simple question, sir.
Mr. Tony is paid.
He's paid. You paid him?
Not in full, but Mr. Tony is paid.
All right, that's your sworn testimony under oath.
You want me to do it again?
No, I don't want you to do it. I just want to make sure that you don't want to recant any of your testimony. Okay, so where is Mr. Tony this morning then?
Like I said, I talked to him. I had talked to him on Monday, and I went and seen him yesterday, and he said he had to do something. I don't know. Like I said, it was a court date. I was releasing somebody on Monday, and they said they're gonna set it off to Thursday or something.
Sir, have a seat back out in the gallery. I want the clerk or someone to call Mr. Tony's office and see what the situation is. Can you do that? All right. We'll recall your case, sir. Cerise Loomis.
Good morning, Your Honor.
How are you today?
I'm doing well. How are you?
You're Ms. Flowers?
Yes, sir. I'm with Office of Regional Conflict on behalf of Ms. Loomis. Good morning again, Your Honor. Jennifer Flowers on behalf of Ms. Loomis with the Office of Regional Conflict. We're here in 23 CF 369 on a bond hearing. I filed a motion for bond with the court. I'm sure you have it pulled up. Ms. Loomis was arrested back in February and was released on an ROR bond. There was then an affidavit from pretrial stating that she allegedly violated conditions of her pretrial release, so her bond was revoked. And her bond has been revoked. She's been in jail since March 24th, 2023, so over a month. So we're asking the court to reinstate her prior ROR bond and perhaps place her on heightened reporting, intensive reporting, and she wants the court to know that she is the sole provider for two minor children.
Yes, sir, and I'm the only person that pays the bills. My rent's coming up soon. I don't have any family. My neighbors do have the children at this time, which that can only go on for so long. I know it's not your problem. Everybody's under the same status, I'm sure, but I'm just asking if you'd take that into consideration, please.
All right, so let me understand. She was on ROR, and while she was on, then she was released, and then she got rearrested?
She was rearrested on an order revoking bond for violation of pretrial release. There were allegations that she was, I think, drinking, and that was a violation of her pretrial release. So she
I also want to add, since that time, I've done other requirements. Obviously, there is Families First Network involved thoroughly in my life now because of some of my poor decision-making. I have signed up with Bridgeway and met all the requirements and my classes, and things are supposed to start. So obviously in here, I can't take advantage of the help from the facilities, which I'd like to, because obviously there's an issue if I'm running this cycle that I'm in.
Right, one of the charges she was arrested with was DUI, is that right?
Correct.
State want to be heard?
Yes, Your Honor, the state is opposing reinstatement of her bond. She was given an opportunity by the court with the RR bond to be in the community pending her charges being addressed by this court. And part of that was not to drink alcohol or use opiates to excess or in violation of any non-prescription drugs, and also to comply with the DCF case plan so that she could properly care for her children, since she's also charged with child neglect. Then she violated by refusing to cooperate with DCF. The investigator indicated that she just refuses to do anything she's being asked to do. She did test positive both for alcohol and opiates, so she's shown this court that she cannot comply with the terms and conditions of her release. So we are opposed to it based upon that. Additionally, Your Honor, we would point out her history is very extensive, including resisting, escape, numerous drug charges, battery, fraud, and battery upon a person over the age of 65. So she will score out presumptively to DOC as well as if she is found guilty of these charges.
I'm of the opinion that she's not entitled to a bond on this charge. She may be entitled to a bond on the new law, the one that she was rearrested on, but on this one, she was on bond, ROR, she violated terms. I'm going to deny the motion.
Thank you, Your Honor.
Thank you.
Does the state have?
You're welcome, discuss.
Haley Stofflet?
You can't take it now.
Ms. Flowers, this is Ms. Stofflet?
Yes, this is, Your Honor, this is Haley Stofflet. We're here on a VOP in 20 CF 453. For purposes of today, we're going to enter a denial and ask to set it on May 4th. I know that's a short time period, but I have some information that I'm going to get to the state attorney before then that I think will resolve it.
If we put it on May 4th, it'd be without subpoenas.
Yes, Your Honor.
That's, any objection?
No objection.
All right, ma'am, we're going to reschedule your case for May the 4th at 9 o'clock. You need to stay in touch with your attorney, be back in court that date and time. Daniel Whitted.
Your Honor, this is Daniel Whitted, 21 CF 3051. Your Honor, we're going to ask to continue this. I think we've previously entered a denial. This charge is the basis of a VOP in a different county. I was under the impression he was going to be transported to that county by today. So we're unable to do anything other than continue today.
Yes, Your Honor, there is an active transport order down from Sarasota, I believe. So if we could set this off to the next miscellaneous docket, maybe the end of May.
What would that be, May 30th?
May 30th.
All right, we'll go ahead and I'll grant the defense motion for continuance. We'll pass it to May 30th at 9 a.m. Okay, thank you. Ms. Flowers, do you have any others, or was that the last one?
I think that's all I have on this morning's docket. Yeah.
Okay. Jennifer Albro.
Thank you, Your Honor.
Mr. Gibbs' case. Where is Mr. Gibbs?
Judge, we reached out to Mr. Tony's office. There's no answer. We walked across the street to it. Office is dark.
Okay. I see the defendant has left the courtroom.
Hallway.
In the hallway? Okay.
behalf of Jennifer Albro. This is 21 CF 2514. I haven't had the opportunity to fully speak with Ms. Albro about her case. I'd like to reset her to next week, May 4th at 9 a.m.
No objection.
All right, without objection, it'll be May 4th at 9 a.m.
Thank you, Judge. That's all. Come see you.
Mr. Sledge? Mr. Sledge? All right, Mr. Sledge, we tried to locate or contact Mr. Tony. Apparently, he's out of his office. What I'm going to do is I'm going to pass your case till next Thursday, May the 4th, at 9 a.m., and you need to be back in court with your attorney at that time.
All right.
Okay? Get up with Mr. Tony. Tell him May the 4th at 9 a.m. All right, thank you, sir. Edgar Batson?
Your Honor, Tim Gibbs on behalf of Edgar Batson. Judge, I believe he's on docket this morning for 21 CF 733. He also has a new law violation, Judge, 23 CF 801. Today, Judge, we'd like to enter a denial and a plea of not guilty as appropriate on these cases. I'd like to leave him set for next Thursday, May 4th, to have an opportunity to go over his case with him.
No objection.
All right, without objection, we'll pass it to May the 4th at 9 a.m. Blake Calero?
Judge, Tim Gibbs on behalf of Mr. Calero. This is 18 CF 3154, 19 CF 1013, 19 CF 1014, and 20 CF 1756.
These are all VOPs.
These are all VOPs, Judge. This is, he's basically passed his termination date. He owes some restitution and some court costs. I'm not sure exactly the state's position. I know he's tried to make payments. I just don't believe he has the ability to pay all of it off. There's about $5,500 total that he owes. But I know he's made payments while he's on probation. I don't know if we can just move everything to a collections or to a lien.
When is the termination date?
It's passed.
It's passed. May I have 1 minute to confer with probation, Your Honor?
Yeah, when you do that, what I need to know is whether or not he was, the warrant was signed before probation terminated and when he was arrested. Okay.
So that the period is told?
I believe it was.
Yes.
But we can.
He was arrested before the warrant was.
Yeah, the warrant, the affidavit by probation was filed before his termination date.
Okay.
Yes.
Yes, Your Honor. May I?
Yes, ma'am.
Yeah. So if we could pass him for just a moment while the state checks that. Just have a seat for right now.
Mikhail Coughlin.
Your Honor, Tim Gibbs on behalf of Michael Coughlin. This is 22 CF 873, if I could just have 1 moment. Judge, we're going to be starting negotiations with the state on this. I'd like to leave him set for next Thursday, May 4th, at 9 a.m.
If I do that just for a week, it'd be without subpoenas.
Yes, Judge.
All right, let's pass him to May 4th at 9 a.m.
That's fine, Your Honor.
What'd you find out?
Yes, Your Honor. The state at this time would be willing to send all outstanding monetary requirements to judgment and revoke and terminate probation, adjudicate the defendant guilty.
Mr. Calero.
Mr. Calero, come on back, sir.
And that's just time served.
Yes, yes.
So, did you hear what you? Judge, I think we can enter an admission to work that out for essentially revoking and terminating probation, moving all the outstanding monetary requirements to a lien, and just sentencing him to time served.
All right, Mr. Claro, would you raise your right hand to be sworn? Do you swear or affirm the evidence you're about to give be the truth, the whole truth, and nothing but the truth? Is that what you want to do this morning, sir? Admit the violation of probation, you'd be adjudicated guilty, sentenced to time served, and all the financial obligations would be reduced to a monetary judgment, and your probation would be terminated. Is that what you want to do? Anybody force or coerce you to do that? Pardon me? Anybody force you to do that?
Oh, no, I'm sorry.
Okay. All right, and he's admitting the violations of all 4 cases?
Yes, Judge.
All right, I'm going to find that the violation of probation, his admission is freely, voluntarily, intelligently entered after he's had the benefit of advice of counsel. He'll be adjudicated guilty on the violation of probation, all the cases, sentenced to time served on all the cases, and any outstanding fines and costs, restitution, or any monetary obligations will be reduced to a judgment lien for which let execution issue. So you have, and his probation on all cases will be terminated. So you have a right to appeal the legality sentence of the court. If you can't afford an attorney and want to be appointed, you have 30 days from today to file your notice of appeal. Good luck to you, sir.
Thank you, Judge.
Your Honor, if I may, for the record, this scores a total of 28 points. I am printing the score sheet and I will file it right away within 2 minutes.
Okay, that's a total of 28.4.
Points, yes.
So this is not a downward departure?
Absolutely, no, Your Honor.
Okay.
Thank you, Judge.
Jasmine Cobb. Okay.
I believe it's a gentleman.
All right, we'll recall her.
It is a man.
What about Tristan Colley? Is that her?
Your Honor, Tim Gibbs on behalf of Tristan Colley. This is 20 CF 1418. Judge, we recognize that we have a conflict of interest in representing Mr. Colley. We will be filing a motion later today to withdraw due to that conflict. So unfortunately, I cannot provide him any advice. If the state wants to announce their offer, that's fine.
One moment, Your Honor.
All right, Mr. Colley, your attorneys indicate they have a conflict of interest, and because of that, they can't afford you representation. You're still entitled to be represented by an attorney. If you can't afford an attorney, I'll appoint one for you outside of the public defender's office. Do you want me to do that, sir?
What do you mean conflict of interest?
Well, I'm not exactly sure what it is because they haven't filed their motion yet. I guess Mr. Gibbs can tell you.
It involves a witness. I believe you're a witness on another case in Santa Rosa County where we represent that defendant.
May I announce the offer, Your Honor? Because it will be an offer for which it will be released. It would be to revoke and terminate new term of supervision, community control for the remainder of the probation term.
Which is how long?
I get off in November.
Your Honor, Charles Bureau of State Probation, November the 4th of 2023.
All right, sir, you heard the state's offer. You have, but before we even get there, if you want me to appoint you an attorney, I can appoint you an attorney, sir. Outside of the public defender's office, we have conflict counsel, and it may behoove you to talk to that attorney before, you accept a plea, or if you don't want to do that, I'll go ahead and see what you want to do today.
I'll take that for community control.
Is this a guideline sentence?
Your Honor, no. He scores a total of 16.4 points, so it's not a downward departure.
Okay, so it's a guideline sentence. All right, is
Yes.
that what you want to do, sir? You'd be
Yes,
admitting
sir.
the violation of probation, and the balance of your probation would be, your probation would be terminated, and until November the 4th, you'd be on community control under the community control standards and the same terms and conditions of the original probation.
My grandpa's sick.
That's what you want to do? And you're waiving your right to an attorney? You don't want to talk to an attorney about it first? All right. I'm going to find that he's violated his probation. He'll be adjudicated guilty of the violation.
Your Honor, for the record, I would of course move to withdraw.
I'm going to allow you to withdraw. Yes, sir.
Thank you, Judge.
Based on your conflict, you can withdraw.
Thank you.
and his probation will be terminated. I'll place him on a new period of supervision. It'll be community control effective now, and it'll terminate on November the 4th of 2023 under the same terms and conditions of the original probation. Is that right?
Yes, Your Honor, thank you. And I will go get the score sheet and bring them.
All right.
Your Honor, Charles Beer was state probation, if I may. If we just reinstate him to the original probation with the remaining period on community control, that would be better for us.
All right, we can do that.
State is fine with that, thank you.
Thank you.
You have any objection to that, sir? Basically, it's the same thing. All right, I'm going to reinstate him then on the original probation with the special term and condition that the balance of the probation he'll serve on community control, same terms and conditions. All right, so you have a right to appeal, 30 days to appeal. If you can't afford an attorney, want to be appointed for you, good luck to you.
Oh, that means I get out on CC?
Yeah, when they get you back to the jail, they'll process you out.
Thank you.
Avery Benjamin Collis.
Your Honor, I was informed by detention earlier that Mr. Collis, he's in the jail, that he refused to come to court this morning. We are set this morning for a bond hearing. He's also set for arraignment this afternoon. I don't know how the court wants to approach that, if we want to simply continue this to another time to see if he's willing to come to court so his motion can be heard.
Why does he not want to come to court to have?
I was not informed that. I just was informed that he was refusing to get on the transport van.
He's not here.
So he's not here. He's not here at the courthouse. He's still in the jail.
Okay.
If I may, Your Honor, for the purpose of this bond hearing, the victim in the case has actually appeared, and it's not fair to the victim not having to come back just because he's refusing to comply with his own motion for bond. So I would ask that the bond be denied.
I tend to agree with that. I mean, he had an opportunity to be here. He refused to be on the transport. The victim's here. His motion for bond will be denied.
Thank you.
And do you want to waive his appearance on the arraignment?
If I could, for the record, go ahead and put in a not guilty plea on his behalf for that arraignment. I believe he's otherwise set for pretrial June 26th.
Okay, we'll put it on for June 26th, pretrial conference, July the 3rd, docket day, July the 10th, jury selection, all at 9 a.m.
Thank you.
Our next one is Deborah Corey.
Your Honor, Tim Gibbs on behalf of Deborah Corey. This is 21 CF 1890. She is present, approaching judge.
And you can remove Collis from the afternoon docket then.
So there's...
You're Deborah Corey?
Yes, Your Honor.
Judge, I believe we're very close to resolving this today. I just want to confirm a few things with the state. If we could pass Ms. Corey for now, and I can recall her back this morning.
All right, just have a seat, Ms. Corey. We'll recall you. Brian Crocker.
Judge, he's also set this afternoon for arraignment in 23 CF 626. I'd like to just leave him set there to see if he shows up then.
Okay, we'll do that. We'll pass this case to this afternoon.
Thank you,
Tierra Demby.
She's already at the state hospital. Your Honor, on Ms. Tierra Demby, she is already at the state hospital on 4 other case numbers. She was found not competent to proceed by this court in those 4 case numbers. This 5th case number, Judge, that's come out, 23 CF 828, she was charged with that after she was committed to the state hospital. I have filed in discovery with, as well as with the court, the evaluation reports from Dr. McDonald as well as Dr. Zeman recommending that she be found incompetent and sent and committed to the state hospital. That's what she is noticed for here today. That's what I'm recommending, asking the court to do is following the recommendations from those 2 experts, submitting their reports into evidence that she be committed to the state hospital due to being found not competent to proceed.
All right, let me look at the reports. You said you filed them?
I filed them in discovery on April 20th.
Oh, I see the discovery. Okay.
Yes.
This is a report from Psychological Associates.
That's the first report. That report, Judge, that evaluation was done in November of 2022. The following report is from Cornerstone Psychology with Dr. Randy McDonald. That evaluation was in February of this year. The report was dated March 17th of this year. That most recent report is the one that recommends that she be committed to the state hospital.
Dr. Zeman's report also indicates she's not competent.
Correct.
Second report, okay, I see. Cornerstone?
Yes, Judge.
All right. I've also got the report from Dr. McDonald, Randy McDonald. All right, I'm going to find the defendant, Ms. Demby, not competent to proceed and order that she be committed to Department of Children and Families for further education and treatment. And that'll be concurrent with her other cases. And I'll need you to prepare an order to that
Certainly.
effect.
I'll send an order today.
And you can put it in my electronic file.
Very well.
Okay, thank you, sir.
Thank you.
Jolanta Durham. Is a bond hearing?
Yes, Your Honor, we filed a motion to reduce his bond. Your Honor, Tim Gibbs on behalf of Jolanta Durham. This is 23 CF 591. Your Honor, we're here for a motion to set, reduce, or modify bond. Judge, he's been in jail since March 14th of this year. He has a total bond of $605,000 cash or professional. He is unable to furnish that. It's an excessive amount to where he is unable to furnish that. We are requesting either an RR bond or a total amount of $20,000 total cash or professional, Judge. He'd also be amenable to pretrial supervision if that's not already been ordered by the first appearance court. He has lived in the area for life. He would reside locally here in Crestview. He's employed by his family's home repair company. He was trying to obtain his GED before his arrest. I don't believe he's ever missed court, as far as I could tell. So I don't believe that there's any reason, or there's no reason to believe that he would not appear in court if he was granted a reduced bond. And therefore, we're asking for a total, either a signature bond, ROR bond, or a total of $20,000 cash professional.
He's charged with 5 counts, is that right? Attempted
Yes, Judge.
first-degree murder, throwing a deadly missile at an occupied vehicle, ag assault with a deadly weapon, criminal mischief, and discharging a firearm.
Correct.
They want to be heard?
Yes, Your Honor. The state objects to defendant's request to reduce the bond for the following reasons. One, the nature of the offense, the potential punishment that this defendant is facing, the fact that he has accomplices and other people who are presently being charged as accessories, helping him out, covering up the evidence, such as the weapon that the defendant used. The evidence that the state has, it's a lot. We have witnesses, victims, who are cooperative and are certainly objecting to the reduction of this bond. People's lives was endangered that day. There were children present who witnessed the attack and the shooting of the defendant. 4-year-old children advised that the defendant had a gun and he was walking from the back of the house to shoot. The only reason why it's not a homicide and it's just an attempted homicide, simply because this defendant missed. Evidence shows that the location of the bullets in the car occupied by Miss Smith hit the passenger headlight, the top part of the door, passenger door, and the part where the mirror is. It was by a miracle that Miss Smith didn't die. At the time of the shooting, there were also infant children in the hands of other witnesses in the arms. The state believes that due to the nature of those charges, the fact that this defendant has been actively trying to tamper with the evidence and avoid prosecution, this motion should be denied.
Judge, responding to that, again, the primary concern for a bond is to ensure that he makes his appearance in court as required. Ms. Leone said that, it's a miracle that Ms. Smith was not killed. However, based on her own statements to police, if I'm not mistaken, I'm trying to confirm that in the arrest report, it doesn't appear that Ms. Smith even knew that the vehicle was hit. She did say that there were shots fired. However, she didn't realize that the vehicle had even been hit. So if she is indeed an eyewitness to Mr. Durham having a gun in his hand and discharging it, she wasn't aware that the gun was fired at her vehicle. Otherwise, this is the first I'm hearing about accessories being charged. I haven't seen anything of that sort come across our desk anyway. But again, the point of a bond is to ensure his appearance in court. Speaking with him, he does, he does indeed maintain his innocence. He's still presumed innocent, stating here today. We're again asking for a total of $20,000 cash professional as a bond that he can make, again, with pretrial supervision, being amenable, of course, to no contact with the alleged victims, and as well as no contact with any potential accessories that may have been charged as well.
All right. Well, read the probable cause. It's fairly aggravated. I'm going to deny the motion for bond reduction.
Thank you.
He was also, according to probable cause, he was picked out of a lineup as well, from what I understand. So, motion for bond reduction is going to be denied.
Understood. Your Honor, he's also set for arraignment this afternoon. I believe we'd like to tender a not guilty plea and leave this set for pretrial June 26th.
All right, we'll set it for pretrial June 26th, docket day July 3rd, jury selection July 10th, all at 9 a.m.
Thank you, Judge.
Justin English.
Your Honor, Tim Gibbs on behalf of Justin English. I believe this morning he's set for 22 CF 3185 and 21 CF 2151. Judge, we'd like to enter denials this morning. If I could have him set for May 4th next week at 9 a.m. without subpoenas to discuss his case with him. I haven't had the full opportunity to discuss his cases with him.
No
yet.
objection.
All right, with that objection, we'll pass it for 1 week, May 4th at 9 a.m.
Thank you, Judge. Yeah, I'm on MC.
Jessica Eubanks.
Your Honor, Tim Gibbs on behalf of Ms. Jessica Eubank. This is 19 CF 2332. If I could have just one moment.
This is a VOP.
Judge, we do have an agreement with the state. I just need to write that up. If I could pass her, we can recall her later this morning.
All right, we'll recall your case, Ms. Eubank.
Team court. Yeah, I'm gonna come. So yeah, they'll bring it back out. Yeah.
Joseph Gainey.
Your Honor, Tim Gibbs on behalf of Joseph Gainey. This is 18 CF 408. Judge, I believe we also might be able to resolve this morning. I just need to confirm how much credit he has with the jail as well as DOC, so I'd like to pass him as well and recall him later this morning.
All right, we'll recall your case, Mr. Gainey. Joyce Grice?
Your Honor, Tim Gibbs on behalf of Joyce Grice. This is 23 CF 608. We are set for a bond hearing this morning, but if I could have just one moment with Ms. Grice. Judge, I just need to write up a written plea. I believe we have reached an agreement with the state. I'd like to write that up if I could pass Ms. Grice for now and recall her later this morning.
Okay, so you don't need the bond hearing?
For now, yes, I'm going to withdraw the bond motion in light of Ms. Joyce Grice being, or wanting to accept the state's offer at this time.
Jeffrey Gunter, ma'am, you go ahead and back there, we'll call you. Jeffrey Gunter?
He's an inmate, Judge. Your Honor, Tim Gibbs on behalf of Jeffrey Gunter. This is 21 CF 800, if I may have just one moment. Your Honor, on Mr. Gunter's case, we'd like to enter denial and leave this set for May 25th without subpoenas.
All right, you want to set it for May 25th?
Yes, Judge, in the morning without subpoenas.
Without subpoenas? All right, we'll pass this case May 25th, 9 a.m.
Thank you, Judge. All right, Mr. Gibbs. Yeah, I'll come talk to you.
Your Honor, before you call the inmate, that person's mine, I do have someone out of custody. I was wondering if we could go ahead and call him.
Who's that?
He's on the afternoon docket. His name is Gerald Parker, number 18. He came at 9. He thought his court time was 9 a.m. So if we could just enter a not guilty plea at this time and set this matter for June 26th.
All right, you're Mr. Parker? Yes, sir. All right, sir, I'm going to, your attorney's entered a plea of not guilty for you. I'm going to set your case for pretrial conference on June 26th. Your docket day be July 3rd, and jury selection will be July the 10th, all at 9 a.m. You need to stay in touch with your attorney, be back in court those dates and times. That's a condition of your bond. Okay? Thank you, sir. You have others who are not in custody that you want to call, or you just want to go down the docket?
Just go down the docket, Your Honor, that's
All right.
fine.
Tyler O'Quain. He's got 2 cases.
Yes, Your Honor. I believe we've reached an agreement in the second case, which would be 22 CF 523. The state is willing to stipulate that count 2 is double jeopardy, and that would need to be deleted from his charge, removed. So we're here before the court on our motion to dismiss under case number 21 CF 1972. In this particular case, he is charged with 5 counts, 2 counts of obscene communication, 1 count of traveling to meet after use of computer to lure a child, 1 count of use of a two-way device, and 1 count of transmission of pornography to a minor. Your Honor, This is basically 5 counts for the same conduct, and double jeopardy, of course, prohibits multiple punishments for different offenses involving the same criminal conduct. And I have cited the Florida Constitution and the United States Constitution, Florida Statute 775.021 sub 4, and then there is Florida Supreme Court case law, Levy State, 238. Copy to the state.
I have a copy now.
If I may approach, Your Honor, with case law. If I may approach with case law.
Looking at your motion now.
And Your Honor, originally, I had argued in the motion that I believed counts 2, 3, 4, and 5 were duplicate of count 1 and should be dismissed, but upon further review, it looks like the better argument is counts 1, 2, 4, and 5 are duplicate and can be subsumed into count 3. At any rate, we are asking the court to dismiss 4 of the 5 counts, because they are alleging the same criminal conduct, and when, according to Levy State, the court is not to look at the facts of the case. The court must look only to the charging document. And the case law reflects that double jeopardy principles prohibit separate convictions and punishments based on the same conduct. In this particular case, the person had been charged with traveling to meet a minor, unlawful use of a two-way device, and using a computer to facilitate or solicit the sexual conduct of a child. And the court found that 2 of the counts did merge into the one. And in this case, we have those charges plus 1 or 2 additional ones. And I believe there's only 1 appropriate charge in this case. The rest are, in fact, double jeopardy. And I believe that the court can determine that from looking at the charging docket, the information in this case.
The only case I see on the docket is the 22-523, and you're actually looking to dismiss 21-1972, is that right?
Yes, Your Honor, I did file for both of them. Yeah, and the clerks indicated they are both listed for being on for today.
Let me see if I bring it up. Towards the information.
Your Honor, we would point out in the 1972, there wasn't amended information file. That's the one we'd be addressing. That was e-filed on.
21-1972.
Correct. It was e-filed on October 4th, 21.
Is that a new law violation or VOP?
New law.
What was the date of the amended information?
Your Honor, the date of the e-filing on the amended information was October 4th, 2021.
now counts 1 and 2 allege 2 different dates.
Yes, Your Honor, but it is the same criminal conduct. It is the same criminal episode, same criminal event. And so I believe that when you review the case law, that different dates alone is not enough. You look at the charging document, the 5th is just a continuation of the 4th. It's the exact same charge. Same person, same charge. So we would allege that it is in fact the same criminal episode, and we believe that it would be double jeopardy to have both counts. And they would, and under count 3, using a computer to facilitate is part of, can be part of count 3. When you look after the part where it's boldface Tyler Quain O'Quinn, to be a child after using a computer online service, internet service, local bulletin board. As you read it, it does cite using a computer. So I would allege that they're all subsumed into count 3.
What's the state's position?
Your Honor, the state would respectfully disagree. First of all, the state would point out that the Supreme Court case that Ms. Rivers cites, the Lee case, is actually based, the decision is based after a trial occurred in that case. So a trial was already heard. During the trial, the facts indicated that it was the same conduct on the same date. In this case, Your Honor, the state would ask the court to consider State v. Scholl, and I do have a copy of that found at 18 Southern 3rd, 1158. It's the first DCA case, if I may approach with that.
Yes, ma'am.
Your Honor, based on that case, and I'm also providing a copy of the defense. Based on that case, Your Honor, that the defendant's double jeopardy argument was premature, and we think it's an improper basis for dismissal because double jeopardy concerns require only that a trial judge filter out multiple punishments at the end of the trial, not at the beginning. And double jeopardy predictions could not be extended to the earlier stage of the proceedings, such as the filing of the information or the jury selection. Otherwise, the trial court would be usurping the state's discretion to make a strategic decision about charging criminal activity. So our first argument is based on Scholl, that this is a premature filing of the motion. However, if the court disagrees with that, then, Your Honor, we would go on to point out to the court that the charges, as the court already mentioned, in the charging document are on different dates. And the facts of the case do support that there were 2 separate, distinct solicitation discussions going on. So based upon the case law, if it's charged on different dates, then you can proceed on those. It's not double jeopardy. So we do believe that it's not a case of double jeopardy if the court disagrees that this is not premature. But we do believe this is premature at this point. Additionally, Your Honor, like I said, we would point out there are different dates. As far as using the computer was on the 4th, then the traveling is on the 5th. And on top of that, Your Honor, there is, on the transmission of the material that is harmful to a minor, that is separate, and those are totally different elements. So it's not even part of the same. In that case, it's using a computer or electronic device to transmit an image to someone the person believes to be a minor. Those aren't even the same elements as using a computer to solicit or traveling to meet a minor. So that, we believe that's really not even part of the double jeopardy argument. Ms. Rivers asked the court to believe this is all part of the same criminal episode. Yes, in terms of the fact that Mr. O'Quain was chatting with an undercover individual that he thought was a minor over the course of a couple of days and then did travel to meet that minor. However, based upon the elements that the state needs to prove and the case law, we do believe that it is not an issue of double jeopardy. He used the computer to solicit the minor to engage in criminal acts on one day. Then on the next day, the state is charged a separate day, as is required by the case law, that he again solicited that minor and then travel to meet that minor. So then we meet the elements on 2 separate days. Additionally, the transmission of material that is harmful to a minor has a totally different set of elements, so we don't believe it can be subsumed as a double jeopardy in using a computer to solicit a minor or traveling to meet a minor, because there was the additional element of the fact that he sent an image to the minor. That is the additional element, so it does not fall under the double jeopardy of using the computer